Okay, folks, let's get started. In this video topic, we're going to talk about doctrines of voluntary intoxication. What happens in this area of law that emphasizes the workings of the mind when alcohol reshapes the workings of that mind? How does it affect what the prosecution has to prove or what the defense can say to try to respond to what the prosecution is trying to prove about state of mind? Let me set to one side what we're not talking about. We're not talking about involuntary intoxication, and we're not talking about those rare cases of intoxication so complete that the defendant claims there was no voluntary act performed at all or it amounted to a form of temporary insanity. We're talking here about the relevance of voluntary intoxication to proof of mens rea. Let's jump in. We know from surveys of victims how often they perceive the offender to have been under the influence of drugs or alcohol. We know from surveys of inmates who are going into jail or into prison their own self-reported rates. How often do they say they were under the influence of alcohol or drugs when they committed the crime? And the numbers are really pretty striking. So at the very least, we're talking about maybe a third of people going into state prisons say they were under the influence of alcohol at the time of their offense. It's a little higher for violent offenses, about 37, 38%. A little lower for property offenses, more like 29%. It goes way up when you're talking about crimes among intimates, violent crimes within the family, let's say, or among people who know each other. It goes as high as 2/3 for among people who know each other, or maybe even 3/4 when you're talking about intimates, family members who are engaged in violent crimes against one another. So this is a major doctrinal question. We're not dealing here with just a few specialized cases, but this is a big part of the flow of cases in the courts. You could say alcohol and crime just go together, like what? Peanut butter and jelly, or as they say on Sesame Street, like Bert and Ernie, or as the Fountains of Wayne might say, like traffic and weather, or what? Like Bonnie and Clyde, like chocolate and vanilla, like salt and pepper, like Romeo and Juliet, Batman and Robin. So under standard criminal law analysis, if you're talking about proving beyond a reasonable doubt all the elements, could a drunken defendant really know if the prosecution has to prove knowledge? Could a drunken defendant have been aware of a substantial risk that certain conduct would be completed or a result would come about or certain circumstances were present? Element analysis, particularly as enforced by the concurrence requirement, suggests that the mens rea at the moment of the crime would be unproven for a drunken defendant. And yet, our widespread intuition suggests that this offender is blameworthy and that we should expand the time frame, perhaps, to focus on the decision to become intoxicated and not just the moment of the crime. We'll begin with the common law approach to this topic. It's embodied in a famous case, Director of Public Prosecutions versus Majewski, case from 1976 in the UK. So there's a brawl in a public house. And Majewski attacks the landlord and some other people, including 3 police officers. He was under the influence of drugs and alcohol at the time, and he claims he just doesn't remember anything about these events. The jury might have believed him, but the trial judge instructs the jury that self-induced intoxication has to be ignored in an assault case. And so there's a conviction, and Majewski appeals, but the conviction is affirmed ultimately by the House of Lords. But what does the defendant claim is the problem with a conviction based on his drunken actions? First of all, he says it's illogical to treat self-induced intoxication any differently from involuntary intoxication. You allow the defense for involuntary intoxication, and the effect on my mind is exactly the same in both settings. Illogical to treat them differently. And second, he says it's unethical to convict a person of an offense if it requires a mens rea and he just doesn't have that mens rea at the time of the offense. What's the reply of the court? Well, in an opinion by Herbert Edmund Davies, or Lord Edmund Davies, one of the most famous law lords of the 1960s and 1970s. By the way, the House of Lords in the UK has an appellate court function. Anyway, in the opinion, Lord Edmund Davies says, nice try, but no. The opinion says that logic can't overcome the public safety imperative of responding to this very real set of social harms that people create when they're intoxicated. And in terms of simple ethical fairness, voluntary intoxication is blameworthy because it's reckless. Now, it's not the same kind of recklessness that we require for the crime itself, but it's a close enough approximation. And he notes that there are a lot of other examples of imputation doctrines going on in the criminal law, like complicity and felony murder and so forth. Now, more generally, the common law allows only a limited use of intoxication evidence for defense. Going back way back to the early common law, Blackstone, Hale, and so forth, they say it can have no exculpatory power at all, this evidence of intoxication. The common law loosened up a bit during the 19th century and allowed some forms of intoxication evidence to help out defendants, but only in a limited category of cases. So intoxication is generally not a defense to a criminal charge if you're talking about a general intent crime, which is most crimes. As Lord Edmund Davies put it, self-induced intoxication, quote, cannot excuse crimes of basic intent. The general intent crimes standard makes some sense because, after all, in those cases, all you have to prove is some kind of general culpability, not a particular state of mind as to a particular element. And proving voluntary intoxication would prove that general level of culpability. On the other hand, for specific intent crimes, intoxication evidence could be a defense. It could be relevant in deciding whether the person has the intent required for the prosecution to prove. So the common law now allows some intoxication evidence to matter, at least in specific intent crimes. Now, the Model Penal Code is similar, but it's not identical to the common law. Model Penal Code doesn't ask about entire crimes, general intent crimes, specific intent crimes. Instead, it asks about particular elements within crimes. So Section 2.08 boils down to this. Under subsection 1, it says essentially that a defendant who is voluntarily intoxicated can use that evidence to negate or to negative proof of the state of mind of purposeful or knowing elements. But subsection 2 says that a defendant cannot use intoxication evidence to prove lack of awareness of a risk for recklessness elements. The section says that such evidence is immaterial if the alcohol caused the unawareness. And of course, the same would be true for negligence, where you don't ask about what was on the mind of that particular defendant anyway. Notice that there are two problems here. We could call them mens rea switcheroo problems. One of them is that it converts negligence as to the intoxication. If you're negligent as to becoming intoxicated, it is voluntary intoxication. So you're converting negligence into recklessness in some circumstances, and that may be a problem. And second, it switches the object of the awareness. So while you might be reckless as to becoming intoxicated, that's not quite the same thing as being reckless as to a risk of death or some other serious outcomes. And finally, in addition to the common law position that focuses on entire crimes, general intent versus specific intent, and the Model Penal Code position that focuses on elements, the recklessness elements versus the purposeful and knowing elements, you've also got a number of states that have struck out in all kinds of different directions here. You'll see an amazing disunity here among state criminal codes. They're just all over the place here. So you will find some states that tell juries to ignore the evidence of intoxication entirely for all types of crimes or elements. You'll have some states that allow it, but only for purpose elements. You'll have some that allow it for purpose and knowledge, some that allow it for purpose and knowledge and recklessness, but that still won't save you in negligence claim or in negligence elements. So there's amazing variety here. Let's get together and talk about that. See you then.